Here are the 4 names that they had. These should have been the only names that Blake Lively's side could have subpoenaed. Billy Bush, Andy Signore, Candace Owens, and Perez Hilton.
In what may be one of the most spectacular legal PR failures in recent memory, Blake Lively's legal team has been caught in a web of their own making. New evidence reveals that the actress's high-profile lawsuit against director Justin Baldoni has devolved into an unethical campaign targeting dozens of independent content creators, a strategy that has now completely backfired. The unsealing of critical interrogatory responses has exposed not a sophisticated smear campaign by Baldoni's team, but rather a desperate and misguided attempt by Lively's attorneys to silence commentary through intimidation.
A response from a pro-Blake Lively side after realizing they've been duped. So my thoughts on this are probably less generous. I started having doubts on Sunday evening, and I'm sad to see that I was right in this instance. This was a PR move. It could have been a coincidence that Hudson filed her motion just as letters from content creators were dropping. That being said, I think her motion was worded in a way that wanted us to think that content creators were on TAG's list, and it sucked.
What emerges is a cautionary tale about overreach, the misunderstanding of modern media landscapes, and the dangerous precedent of weaponizing the legal system against independent journalism. The Blake Lively versus Justin Baldoni legal saga began nearly 8 months ago, emerging from workplace allegations during the production of It Ends With Us. Lively filed complaints alleging inappropriate conduct and harassment, while Baldoni and his team have maintained their innocence throughout the proceedings.
And Fritz can exaggerate and blur the lines between facts and lies. I would disagree with that. Blake's lawyers cannot do that. Not when the loudest content creators are pro-Baldoni and when they're being subpoenaed in this case. It was a poor attempt at PR and it will backfire on Blake and her team. And maybe Blake's lawyers have a reason to subpoena the content creators, or maybe it's a fishing expedition. However, insinuating that they were subpoenaed because TAG put them on the list was a shitty move that in the end did more harm than good.
However, the case took an unprecedented turn when Lively's attorney, Ezra Hudson, filed motions to subpoena dozens of content creators who had covered the story. The legal filing suggested these creators were part of a coordinated campaign orchestrated by Baldoni's public relations firm, TAG. This move immediately raised red flags within the legal community and among First Amendment advocates, as it appeared to target independent commentary and analysis.
It's unsealing. It is now confirmed that Wayfair utilized TAG to communicate and coordinate with content creators to create content on behalf of Wayfair, directly targeting Blake Lively for her protected activity of making safety complaints and asking for workplace accommodations due to safety. What?
The strategy seemed designed to create a narrative that Baldoni had manufactured public opinion against Lively through paid influencers and content creators. If proven, such coordination could potentially support Lively's claims of a deliberate campaign to damage her reputation. The recent unsealing of TAG's response to interrogatories has completely dismantled Lively's team's narrative.
The revelation that Wayfair was indeed working with content creators on a deliberate PR smear campaign against Lively isn't TAG's only issue. However, in the recent hearing, people that were employed at TAG during their initial engagement with Wayfair had claimed that TAG's engagement with Wayfair ended in September of 2024.
The public relations firm's disclosure, marked attorney's eyes only pursuant to protective order, revealed only 4 names of individuals they had contact with: Billy Bush, Andy Signore, Candace Owens, and Perez Hilton. Critically, the interrogatory specifically asked for any contact with in any manner, a broad standard that would include even basic interview requests or information inquiries.
It becomes clear then why TAG had originally tried to limit their responses to interrogatory number 5 to the date of Lively's filing her CRD complaint. It proves that TAG's claim their engagement with Wayfair ended in September is not true, and they continued their smear campaign against Lively through the end of 2024 and likely into 2025.
The presence of these names on the list does not indicate financial arrangements, contractual agreements, or coordinated campaigns. Rather, it reflects standard journalistic outreach that occurs in any high-profile case. The revelation is particularly damaging to Lively's legal strategy because it demonstrates the vast overreach of her team's subpoena campaign.
Baldoni's PR team provided a list of content creators that directly or indirectly provided content or services on behalf of Wayfair, proving out that Baldoni's team had been manipulating a vast smear campaign for almost a year.
While TAG had contact with only 4 individuals, Lively's attorneys subpoenaed dozens of content creators, suggesting either gross incompetence in their legal research or a deliberate attempt to intimidate independent media coverage. From a legal perspective, Lively's team has committed several critical errors that may have long-lasting consequences for their case.
My lawyer has informed me that the subpoena for my account information has been withdrawn. I am relieved, to say the least, and wanted to record something for you and share a little bit about what's happened in the last few days.
First, the broad subpoena campaign against content creators appears to constitute what legal experts term a fishing expedition, attempting to discover evidence without a reasonable basis for believing it exists. Second, the strategy reveals a fundamental misunderstanding of how modern media ecosystems operate. Independent content creators, like those targeted, often have substantial audiences and significant financial resources. Figures like Candace Owens, with an estimated net worth of $90 million, are unlikely candidates for paid influence campaigns. The suggestion that TAG could afford to pay such high-profile personalities for coverage appears financially implausible. Third, the legal team's approach has violated basic principles of proportionality in litigation. Subpoenaing dozens of individuals based on contact with only 4 represents a massive overreach that courts typically view unfavorably. This aggressive approach often backfires by generating sympathy for the opposing party and raising questions about the strength of the underlying case. What was intended as a strategic legal maneuver has instead created a public relations nightmare for Lively's team. The subpoena campaign has had the opposite of its intended effect, providing content creators with additional material to discuss and analyze. Rather than silencing criticism, it has amplified scrutiny of Lively's legal strategy and the substance of her claims. Even supporters of Lively have begun acknowledging the misstep. Social media commentary from pro-Lively voices reveals growing skepticism about the legal team's approach. One prominent supporter admitted to being duped by the initial filing, describing it as a poor attempt at PR that will backfire on Blake and her team. The situation demonstrates a crucial misunderstanding of digital media dynamics. Unlike traditional media, which might be intimidated by legal threats, independent content creators often view such challenges as validation of their work and additional content opportunities. The subpoena campaign has effectively created dozens of motivated critics with legitimate grievances against Lively's legal team. The interrogatory revelation represents the second major instance of questionable conduct by Lively's legal team. Previously, the team was criticized for misleading representations regarding an intimate scene in the film, where they alleged inappropriate conduct that video evidence contradicted. Legal observers have noted a pattern of lies by omission and misleading characterizations throughout Lively's complaint. For instance, the filing criticized Baldoni for hiring a friend to play a gynecologist, while omitting that the individual was a highly credentialed actor with Shakespearean training and extensive professional experience. This pattern raises serious questions about the credibility of other allegations in the case. Legal professionals often cite the principle that if a party is willing to mislead on verifiable facts, their credibility on disputed matters becomes severely compromised. The Lively case has significant implications beyond the immediate parties involved. The aggressive targeting of independent content creators sets a dangerous precedent for how celebrities and their legal teams might attempt to control narrative coverage of legal proceedings. The case highlights the evolving tension between traditional media gatekeepers and independent digital creators. Lively's team appears to have operated under the assumption that content creators could be easily intimidated or dismissed, failing to recognize their legitimacy as modern journalists and commentators. Furthermore, the case demonstrates the risks of allowing celebrity status and financial resources to be weaponized against smaller, independent voices. Many of the subpoenaed creators lack the resources for extended legal battles, making them vulnerable to intimidation tactics regardless of the merit of their coverage. As this legal saga continues to unfold, the damage to Lively's case appears increasingly irreversible. The failed PR strategy has not only failed to suppress unfavorable coverage, but has actively generated new criticism and skepticism about her claims. The case serves as a cautionary tale about the importance of understanding modern media landscapes before attempting to manipulate them. In an era where independent voices carry significant influence and audiences value authenticity over traditional authority, attempts to silence criticism through legal intimidation are likely to backfire spectacularly. Moving forward, this case may establish important precedents regarding the protection of independent commentary and the limits of celebrity legal strategies in the digital age. The ultimate resolution will likely influence how similar cases are approached and whether the legal system will tolerate such broad attacks on independent media coverage.